It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is Attorney Matthew Noyes. I am one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the oldest and longest established personal injury law firm in Tampa Bay. We have been helping people since 1955, and we are here to help you, not just at our law firm, but also here on the radio. This is a live call-in talk show. We are here to answer any questions you have regarding our areas of law, which are car accidents, slip and falls, personal injury matters, workers' compensation, and Social Security disability. The number is 727-441-3000 if you want to get your question in early. There are times that the lines get so filled up that we're not able to take all the calls. So earlier the better. Again, it's 727-441-3000. I am here, but I'm not here alone, thank goodness. My friend and my partner, Lori Robinson, is here as well.
Yes, very happy to be back in the seat again here at Tan Talk.
Yeah, we're great to be here. Lori, thank you always to share your knowledge. Lori is a board-certified civil trial attorney, something that only about 2% of the attorneys in Florida are. We're fortunate to have two in our firm, Lori and Brian Caulfield, another partner at the firm. They're both board-certified civil trial attorneys. Lori and I work on all our cases together. She is very well versed in, of course, civil practice, which is our area of personal injury, but also in Social Security, disability, and workers' compensation. So, Lori, why don't you just tell the listeners, I'm sure that they have heard you in past shows, but why don't you just introduce yourself a little bit while I remember to click on go live on Facebook since I forgot.
Wow. There you go. Yeah, we're learning our technological skills in this modern era. Yes. So, I've been a part of the firm now for 25 years, hard to imagine. And that's
this is your 25th anniversary.
Exactly. Who can imagine? And it's quite amazing to me that's, I've been practicing law for a total of 44 years, which, of course, is, I always point out, I was like 10 or something.
That's right.
I even have to go back to earlier than 10 now. But regardless, so one of the things I love about our practice is that we kind of cover all of the universe of things that involve personal injury. And so, as you were saying, so my particular expertise started out as trial practice in the civil courts. And actually, I started out doing criminal defense many years ago as a public defender, but love the litigation. But then there are these other areas that involve people that get injured if you're injured at work, or you end up with a medical condition, either from injury or just disease, that causes you to be disabled and no longer able to work. That's an area that is, in the scheme of things, they're all kind of interrelated. It involves injury, disability as a result of injury. And so we found that those areas are very overlapping, and it just feels right to be helping anyone that has had that situation happen, either due to negligence of someone causing an accident, or just things that happen in life that leave you in a situation where you are compromised physically or mentally.
Yeah, we do a lot with negligence, and what negligence really is just somebody doing something that they shouldn't have done in a careless way. But our workers' comp cases really don't involve negligence. In workers' comp, the workers' comp statute was supposed to be designed to provide work comp benefits, whether or not the employer was negligent at all.
Which on the surface, that
sounds really good,
right? Because a lot of times we'll talk with clients where there'll be a thought about. That something happens in the workplace that probably is a result of negligence that leads to injury. But that's not always the situation. Probably most times it's just something that happens where the person is injured as a result of working. But even if it is due to negligence, because of the way the law works for workers' comp, you don't get to sue your employer. It doesn't. That's it's all an administrative system that's designed to hopefully get you medical attention and wages quickly. But of course, as we've learned over the years, that can be quite challenging, which is why people often do need legal assistance.
That's right. And I do want to talk more about that, bringing a claim against your employer when we get more involved into the workers' comp aspect of tonight's show. But also, we talked about negligence in the civil action cases, the car accident, slip and falls, and such like that. But we also do Social Security disability, which involves not an insurance company, but rather it involves bringing a claim for benefits to the Social Security Administration. Can you tell our listeners just a little bit about Social Security disability and how it's different than Social Security supplemental income?
Yes, because unless you've had a reason to get involved, most people will have no real appreciation for what the different benefit systems are. So there's Social Security disability, which really is a program that is designed to let you get your Social Security retirement early because you've had a medical disability that prevents you from performing what they refer to as substantial gainful activity, pretty much any work,
Right.
And that's based on your earnings record. And so whatever the benefit payment is, it's calculated using their formula based on your earnings record. But that benefit may not be available to everyone. If you might have a situation where, for whatever reason, due to your age, maybe you haven't really worked that much, or sometimes people work pretty much under the table, which can seem like a great idea when you're doing it, but it does come with certain consequences because you do lose benefits if you haven't paid into the Social Security system. You're not going to be able to get that Social Security disability. But if you're in a desperate position, there is SSI, which is the welfare version of the Social Security disability, and it's Security Supplemental Income. Everything has an acronym.
That's exactly right.
That's one of the simpler ones, actually.
That is.
So SSI is something that's available to people, but you really, if you have a medical disability, you can't work, but it basically is means tested, and you can't have hardly anything. I mean, basically, if you have more than $2,000 in the bank, you won't qualify as an individual. Married couple, $3,000. It's really designed for situations where people actually, they really have no assets, no financial resources to speak of. There are a lot of complicated rules that go along with that. But if you're in a situation where you don't qualify for Social Security disability because you don't have the work credits, or in a kind of a strange little twist, the disability is only really available, your work credits have to be kind of recent, approximately within 5 years of the time you stopped working. So we were talking earlier today about all of the nooks and crannies of the Social Security law. Yeah, but
that's right.
The important part is that if you have a medical condition that prevents you from working, then you do have two potential avenues. One is Social Security disability, which is based on your earnings record. And if you do not qualify for that because of your work history, then you also have the possibility of qualifying under the SSI, which is essentially the welfare version of the disability program.
And I know there's no easy, quick answer to this question, but we're talking about work credits.
Yes.
And you need to have a certain amount of work credits in order to be eligible for the Social Security disability benefits, or the SSDI benefits. What requirements for work credits are there?
Yeah, this is something that I think it's actually kind of important for people to realize for a variety of reasons. But each year when you work, if you currently, I think it's each quarter, if you earn $1,640, so let's say approximately $6,600 for the year, this year, then you will earn the maximum number of credits you can earn, which is 4. And so you're doing that all your life. For Social Security disability purposes, depending on your age, you have to have a certain number of credits. To qualify for Social Security retirement, you have to have 40 credits, and that's basically 10 years of work to be eligible once you hit retirement age for Social Security retirement benefits and the Medicare. But you don't necessarily have to have all 40 credits for purposes of qualifying for disability. It kind of depends on your age. And what you do have to have, which is the thing that's not the short, quick answer, is that you do have to have basically about 5 years worth of work in the last 10. And for most people, if you've had a steady work record, it basically means that if you end up not being able to work because of a disability, you have about 5 years within which those credits are still recent enough under the rules so that you could apply for disability. And they call this the date last insured. So it kind of works like an insurance policy in a certain way, in this way that not true for your retirement. Once you get your 40 credits, you're good. But it doesn't take much to get credits. It's very low level of income to be able to at least get those 4 credits each year. And so even people that have not always worked within Social Security and paid into Social Security, but have sometimes, may have enough credits for the purposes of qualifying for disability. Just depends on what the particulars are.
And we call them quarters or credits. But really, if I understand correctly, you can get your 4 credits for that year, even if you only worked 6 months out of that year, as long as you had the right income
right.
level.
That total, like I say, this year, I think it's approximately $6,600, something in that ballpark. And generally speaking, it's been something around $5,000 to $6,000 going back over. They increase it a little bit each year. So it's a good idea to keep your work credits in force. You certainly want to be sure that you qualify for the Social Security system in general.
Sure.
And so a lot of times, people, for a variety of reasons, will make financial decisions that don't involve working in a way that they're paying into the Social Security system. But it is something that carries with it some consequences that are kind of negative in a lot of different situations, not to mention, when you get to be Medicare age and all of that. Yeah.
Right. I have a couple that I know that the wife always worked with the husband in the cleaning business, but he kind of owned his own cleaning business. And so she just would work and never really got a paycheck, although they shared whatever profits that they made.
Yes.
And she got injured and she wasn't able to work any longer. And she wanted to apply for Social Security disability benefits. But because there was no money actually being given to her as an employee, she never earned any of those credits despite her working for the company for 15 years.
Yes.
So that's the challenge that people sometimes don't think about.
Right.
In those business to business transactions or business relationships that we get ourselves into, that could have dramatic impact years down the road regarding Social Security disability.
Yes, and so it really is something that particularly if you have a small business, probably need to get counsel on that. A lot of people will go that route because it makes sense at the time.
Right.
But if you have something happen, unfortunately, it puts you in a difficult position. So when you get retirement age, then as a spouse, you can get 50% of their benefit. But even that, it's something that should be looked at. And, I don't really know, we might not want to know the percentage of people that will experience a disability that requires them that really impacts their ability to work over the course of their life, but it would be a higher number than we think, yes.
Because we're not just talking about a physical disability. We're talking about a disability that could be physical, but it also could be mental.
Yes.
We have a lot of cases that we help people that are struggling mentally, which prevents them from being able to work.
Right.
And so it's important that when we talk about Social Security disability, we're talking about the whole person.
Yes.
In an auto case, we can only really talk about what body parts were injured in that auto case. In a workers' comp case, what body parts were injured in the work injury. But in a Social Security case, we want to talk about all the impairments that the person has. Isn't that right?
Because they will all have an impact on the person's ability to perform the functions that you have to be able to perform to work.
Right. And just because 1 or 2 or 3 conditions together may not make you disabled, if you add the other 3 or 4 or 5, the accumulation of those disabilities could make somebody unable to work.
Yes, because actually what Social Security is, people will often talk to us about well, I have this diagnosis, that diagnosis, terrible conditions, very difficult things. But that's sort of a given in Social Security disability, that you're dealing with some medical issues that are going to be difficult. What they're concerned about in Social Security cases, though, is how is that limiting you? So that combination of things. So if you have a back condition that makes it difficult to sit for a long period of time, or maybe stand for a long period of time, that's one thing, and that's going to create some obvious difficulties with different types of work. Suppose you add to that you have a very serious anxiety disorder, so you really can't focus at all on things.
Right.
And maybe that's exacerbated by the physical condition and the pain you're dealing with.
Sure.
All of those things could come together to limit your ability to function in a meaningful way in an office or other work setting.
And what drives me crazy a little bit is because you and I and our firm handles a lot of these claims, and we see a lot of people really struggling.
Oh, yes.
Having to file for Social Security disability. I get a little perturbed when people say, oh, they're just trying to milk the system, and there's people just on Social Security disability, and they don't have any injuries. I've seen my neighbors, and they're on Social Security. Those
Right.
people don't know what those people go through.
Yeah, and it's one thing that you certainly learn in our line of work is that you cannot tell a book by the cover.
Sure.
And so obviously a person that has a physical ailment that you can see, maybe they have to use a walker or they're in a wheelchair or what, those are things you can see. But many, many conditions are not things that you can see.
No, exactly.
You really can't.
Billy Joel has a song called "The Stranger," and it's about putting on mask, and that's really what I think our clients do. They have to put on a mask in order to just get through the day.
Right.
But could they get through the 8 hours of work with the physical and the mental disabilities that they have? They would love to.
Right.
Many of our clients, I would say the vast majority of our clients, would rather not even talk to us and rather
Yes.
just go to work.
Oh, yeah. Many times I'll have to explain to somebody, you should not feel ashamed,
Right.
really, because but many people, to reach the point where you really feel you can't work is actually a very difficult place to come for most people. So I think it's mostly that people just don't realize. Now, that isn't to say, I'm sure there may be examples of people that, but the people we represented, I don't see that. I mean,
No.
we aren't going to represent them if we think that they don't have a
Right.
legitimate case, obviously. But I think it's more a matter of actual exposure and really knowing what the situation is. And nobody really wants to reach that place where they're filing for disability. But if you're in a position where you cannot work, it's a benefit, particularly with Social Security disability that you paid into the system.
You paid it. There's your benefits in
Right.
essence,
Right.
So that's Lori Robinson, and I'm Matthew Noyes, and we are two attorneys at the law firm of Perenich, Caulfield, Avril Noyes, proudly presenting FLA Law on the radio every Tuesday night here on the Talk 10 network. And when we're not here on Tuesday, we are in our offices in Clearwater and throughout Tampa Bay. Our website is voiceoftheinjured.com. And our telephone number, when it's not 5 to 6 on Tuesday, is 727-796-8282. We're always happy to answer questions that you have. Before we take our break, I did want to still stay on this Social Security topic, because I think it's very important, especially since what you and I were talking about earlier today, matter of fact, not even preparation for the radio, just talking about today. And that's the misconception of people thinking, okay, I'm on retirement. Now I'm on Social Security retirement. Now I want to go on Social Security disability. Or what happens if I'm on disability and I go to retirement? Can you explain that to our listeners?
People have the idea that there's different amounts involved, that somehow one benefit is additional. But what happens once you reach your full retirement age, if you're on disability, it just converts to Social Security retirement. And really getting your disability initially, you're getting the calculation at the time you get it for your retirement benefit, but you're just getting it early because of the medical disability that you've been able to establish. So there's no other program. Many times people will be concerned about the amounts and wonder if, shouldn't I be able to get something more? Social Security is based on the calculations that are made under the law, and then there are sometimes increases related to the cost of living, but there's no separate program to go to. So it's a very common misconception.
Right. And is there a way people can find out for themselves what their rate would be if they were disabled?
Yes. And so if you're at all good with the computer, I mean, you can always call Social Security, but of course that can be a long phone call. But that
as long as you have a 4-hour break in your time,
or get very lucky. But if you go onto the computer and you Google socialsecurity.gov, just the Social Security site, you look in the right-hand corner on the top, you'll see a little place that allows you to log in or create an account. You just click there and you can create an account with an email or your cell phone number, text number, that will allow you to go in and see your Social Security record, which is actually very good. It's what used to be mailed, and I think they do still mail.
They stopped them, but I think they started them again or something.
I mean, it's certainly not as frequently, but it's the statement you would get. But this is much better. You can just go online. You can see exactly what your benefit would be, and also check kind of your little earnings record to see, that everything.
They'll tell you how many work credits you have, and if you would qualify based on your work credits too.
Right. Yes. So that concept of what we were calling about the insured date, they'll have that information in there. So very useful. But most people would be interested to know, well, what would my benefit actually be? And that's very easy to find out.
But you do got to be careful, because I have heard that there are some representatives or some attorneys, law firms, that try to copy the look of Social Security just a little bit, so they can capture that information for marketing purposes. So really, all you got to do is check to make sure that when you get to the website, it's .gov, G-U-V.
Yes, and that's important, isn't it? You can. There's so many scams out there.
Right.
The emails you'll get and things like that look kind of like Netflix or this, that, or the other. So you got to watch for that with anything with Social Security too, for sure.
Right, because I think this is one of the few areas of law that you don't need to be an attorney to represent somebody in a Social Security disability or Social Security claim.
Mm-hmm.
Of course, you and I disagree with that. I think it's only right to have an attorney to handle the claim who understands the courtroom and understands the rules of evidence and such like that. But you could have a non-lawyer or non-legal representative.
Right, or a friend or a family member. But I will tell you, which, as I would say, I've been doing Social Security probably about the last 20 years, I would say. Yeah. And it is astounding to me, the complexity of it. I cannot imagine. I mean, on the surface, it seems simple. You think you just go in, tell the judge, you fill up these forms. They have you fill, one form out, and then the same form again and again and again. And it seems like it should be something you could do on your own, but it really isn't. Yeah. So I think I'm sure there may be non-attorney representatives that perhaps are experienced, but obviously we would feel that your best bet is to have an attorney that's experienced.
Do they get paid less? The non-lawyer representative?
No, I think it's the same. It's exactly the same. Right.
It's the same as that.
Because Social Security, it's the government. It's a bureaucracy. But they've got a rule for everything. So the fees are pretty much set out.
And what are the fees on a Social Security disability claim?
The way that cases are handled are the Social Security sets forth a fee of 25% up to, currently they set a maximum currently it's $7,200, but it's 25% of what the back benefits are.
The back benefits.
And so because these cases often will take a couple of years to go all through the system, there typically would be some back benefits. Social Security will deduct 25% up to that maximum out of those and send that as the attorney fee. And so that's the standard way anybody that you would contact would handle things.
So it's 25% up to $7,200.
Yeah.
Whether you have a lawyer who went to school for to present cases or a non-lawyer representative.
Yeah, you're not getting a break.
And it's important to point out that it is on the back benefits. Because I mean, you and I have represented some really good people that I can remember somebody that was in a wheelchair that had MS, and they were fighting. We were fighting. It was a no-brainer. And fortunately, we got them benefits somewhat quickly.
Yes.
So the back benefits were small, which is a good thing.
Right. That is our goal. I mean, we try to get the case through the Social Security system as quickly as possible and approved. That those are challenges, except in a rare number of cases, but it does happen, and we're happy about that.
Right.
Yeah.
The fee. I think the fee in that case was less than $1,000, but we felt even better for that case because they really needed needed it right now.
That is why we do the type of work we do.
That's right.
Basically, is to take our experience and knowledge and actually get things done for a client.
Yeah. So you've been listening to Lori Robinson and me, Matt Noyes. We are the law firm of Perenich, Caulfield, Avril, and Noyes. This is FLA Law on the Radio. We are here for another about 28 minutes to answer your questions live on the radio. So if you have a question, give us a call at 727-441-3000, or you can go to our Facebook page too at Perenich, Caulfield, Avril, and Noyes Injury Lawyers and type in your question there. But we're going to take a break right now. We'll be back on the other side.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
Thank you for coming back to FLA Law on the Radio. We are here for another about 30 minutes here to answer any questions you have regarding personal injury law, auto accidents, slip and falls, trip and falls, negligence claims, also workers' compensation claims, and Social Security disability claims. We've been talking about Social Security disability, and something just came out, which is a plus for those that are fighting for Social Security disability and those that are receiving Social Security, not just Social Security disability, but also regular Social Security. And that's the cost of living adjustment, or the COLA. Lori, can you explain to our listeners what COLA is and what's happening in 2024?
Yeah, I think one thing that I do get asked fairly often, it kind of goes back to what we said a moment ago, is people think, oh, there should be some increase in Social Security. Well, there's only one increase that can happen to your benefit based on what your particular record is, and that is the cost of living adjustment for basically inflation. And they really had not done much in terms of increasing the rates for quite a lot of years. Last year it was 5.9%, and this year they are going to increase it 3.2%.
Right. So every person who receives Social Security benefits, whether it's retirement benefits, whether it's social.
But let me just say, I told you I wasn't going to be political.
I know.
But obviously,
I set you up for that one.
It's bad news because, the only reason they're increasing it is to try to keep pace, and it probably doesn't really keep pace, but at least it helps some.
Right.
But obviously, we have a lot of inflation, and we keep hearing promises, and we hope it'll work out, that things get under control a little better. But it is certainly a relief that there's going to be some response to help, because obviously everything gets more expensive and your benefit stays the same.
Yeah, I think eggs are more than 3% higher than they were last year. But
there's a lot of
gas
things.
and
Right.
Yeah, it looks like
gas is down a little bit now, but we're probably getting it from
higher.
overseas.
Right.
Yeah, so it's how stable it is. Who knows?
Yeah, so in 2024, it's going up 3.2. Last year, it was 8.7.
Was it that much?
Yeah, the year before it was 5.9.
Okay, see, I've lost a year there because I remember the 5.9.
But then it was 1.3.
Yeah,
1.
for years
6,
it was very
2.8. There's in 2017 it was 0.3.
Wow.
In 2016.
So it was 5.9 2 years ago. Last year was 8%?
8.7. Almost 9%.
Wow. Jeez.
Yeah.
Well, hey, 3%. We can hope that means things are getting a little more under control. But
right.
So.
But that's the COLA. That's the cost of living adjustment that every Social Security recipient will have. Apparently, it's 71 million Americans will see that increase. But there is something, because we also do workers' compensation, something else came into the news about changes in rates and changes in payment, so to speak. And in 2024, the Florida Insurance Commissioner has decided that they will decrease workers' compensation benefits to not
rates,
workers' compensation benefits.
Yeah.
They've already decreased workers' comp benefits.
That's how they're going to do this.
They're going to decrease workers' compensation rates to employers by an average of 15.1%. Right. That sounds wonderful. 15% off on your workers' comp rates. But what does that really mean to the hardworking Joe or Jill?
Yeah, I think it's the older I get, and anybody that is a little bit older, you recognize, what? There's always going to be consequences to things. And so things can sound good, but what's really happening? So obviously for companies, and do appreciate that insurance is a big factor for them. So the companies are going to be happy that the insurance rates have gone down like that. Well, when do we see things go down? That doesn't happen very often, does it?
No, it doesn't.
And so how do you get that to happen? And what we have experienced over the course of our careers in workers' comp is we see how that happens. Cutting benefits, making it harder and harder for attorneys to even help people.
Fight people, yeah.
Yeah, because we've gone back and forth. We probably will again, where they restrict attorneys' fees so much that it's really not economically feasible sometimes. Now, fortunately, that's opened up because there's some constitutional problems with doing that, because people are entitled to have lawyers and they need to have lawyers to assist them in the system. But so here you got a very dramatic decrease in the insurance workers' comp rates that a business will have to be paying, which we can appreciate that that's helpful to them. But how is that happening? That's a pretty big drop.
Right.
And it's happening by reducing benefits for people that get hurt working on the job.
Right.
And that's, I think, one of the toughest things that can happen to you is being, here you are, you're working, and you're just kind of assuming things are going to go on like they do. And then something, it can be a minor injury or it can be very serious.
Exactly.
And then the person's unable to work and they're dependent on workers' comp benefits. And the way that they reduce these rates is by making it harder and harder and harder for a person to actually get the benefits they need to get back on their feet and able to really resume their life.
Workers' compensation is a system that we have found out that it's one step forward, 3 steps backwards. Every time you fight to get a benefit, you say, okay, they need physical therapy. Okay, you just took 8 months to finally approve physical therapy. Now they need it for longer, or the physical therapy won't help anymore.
Right.
And so,
we had a case not too long ago where the person needed pain management and they needed epidural steroid injection. And so what does the insurance company do? They eventually, after a month, get the person to pain management, and then they refuse to provide the injection for the person. And then it gets to so far down the road, it's like, almost a year. And so now they say, well, we need a new referral for the injection.
Right.
So this is unfortunately the type of thing that is used to reduce benefit because they didn't have to pay for that medical care that the person needed that would hopefully help them, to be able to be more functional.
To get back into workforce and such like that. Now, in that case, the gentleman was working. So, but still, it's like he's working in pain and he's not getting any better.
Right.
Let's get him better.
And creating a circumstance where something that might help him, now he may actually aggravate his situation in a more significant way. I mean, and all the insurance company delays paying a benefit. And that's what insurance companies really, unfortunately, very often do is delay.
Then investigate and then eventually pay if you have the right attorney to understand.
Yeah, exactly.
Yeah.
Or how many times is it the person needs an appointment? So we write the letter to the workers' comp carrier. They need an appointment with the doctor they've been seeing, some period of time's gone by.
That workers' comp sent them to.
Yeah. And then, the law is set up now so that if you file your petition requiring them to set the appointment, as long as they do say they'll do it within 30 days of that, then they don't have to pay a thing for attorneys.
There's no penalty.
So what does that mean? Delay.
Right.
And they're delaying because they don't want to pay. And over a period of time, people get frustrated, give up. I mean, we know the people that come to us, but what about people that just say, you know what, I've had enough of this, what.
The heck with that. I'm going to treat it under my health insurance.
Right. And just ignore it.
It's not fair to the health insurance companies either.
Well, I mean, as the other problem is that it can be tricky to treat under your health insurance because if your health insurance is aware that this was a work-related injury, they're not going to pay for it.
Right.
Because it should be workers' comp.
Right.
So what then happens is that person may actually just go without treatment and just deal with it in that way. So we've now reduced the cost to the workers' comp insurance company. Okay. Great. Here we've got somebody that, the best way to get better is to be able to get the care when you're in an acute phase of injury.
Sure.
Yeah. And so it's really kind of a catch-22 the way it all works, but very unfortunate. We fight those battles all the time.
All the time. And we kind of talked earlier in the show was about that you can't bring a negligence claim against the employer. Mm-hmm. Under the workers' compensation statute, there's work comp immunity that even if the employer was negligent and caused your injury, you're limited to the work comp benefits. Well, way back when the workers' comp statute was created and that provision was put into the statute, there was a quid pro quo kind of thing. You can't bring a claim for negligence, but we're going to give you all these workers' comp benefits.
And they used to be much more generous.
Much more generous. Now they dwindled away those benefits to where there's no quid pro quo anymore. But the employer or the insurance company still has that same immunity, but the benefits aren't there.
And it's very unfair because you could see, I mean, it can be hard to prove negligence, and there would be many instances where there maybe wouldn't be negligence. So in that scenario, you're supposed to get prompt and good medical care and wages, if you're out of work. But there are also plenty of situations where actually you would be able to prove negligence.
Sure.
And in that scenario, you've given up that right. That right's been taken away from the injured worker in return for what was supposed to be an administrative system that got you medical care and wages without any problem. Shouldn't need a lawyer. Should all be great. But as we see, that's not actually how it has played out over the last probably 20, 25, 30 years, I'd say.
And a lot of our workers' comp clients, they say, if we can obtain a lump sum settlement for them. Mm-hmm. But we'll talk about that in just a second. But they always want to know, hey, my life has changed. I'm in pain. I can't do the things I used to be able to do because I got hurt at work. And it's very surprising to the injured worker that those kind of damages don't matter in the workers' comp arena.
Right. And that's where a normal negligence action, someone has injured you as a result of not acting with reasonable care. in that situation, you'd be able to recover damages. I mean, our auto cases or a slip and fall or something like that. If you're injured because somebody basically negligently screwed something up and caused injury, then you can recover your medical, your lost wages, and what we call pain and suffering, the emotional experience that you go through if you've had a significant injury. And
I call them PETA damages, pain in the you-know-what damages. So.
Right. And that's exactly right. But so here now in the workers' comp system, that's been stripped away years ago at the beginning of the 1900s with this supposedly great administrative system to get you your medical care. But as a result, your damages are limited to what the Florida legislature has put in the statute, in the law. And there's no consideration whatsoever for that pain and suffering, or PETA, as you say.
But if there is a work comp settlement or a resolution, a washout claim, what does that entail?
Well, many people will decide that they want to get out of the workers' comp system. And if they are no longer going to be employed with the company they're working for, then they may choose to engage in settlement negotiations and try to reach a settlement of their claims. So the workers' compensation insurance company will be very interested in closing the claim out typically, but needless to say, they'd like to pay as little as possible.
Sure.
But very often they'll have to look. The settlements are really based on what workers' comp would have to pay for the person's lifetime. Because if you are injured on the job, so long as the major contributing cause, 51% or more of the reason that you need medical treatment or lose wages kind of thing is coming from that work injury, they're on the hook for your entire life, at least in theory. For medical, yeah.
Wages end at maximum medical improvement.
Yes. So
unless you're permanently and totally disabled.
Yeah.
But
so that they've got a reason to want to close out that liability from the insurance company's perspective. So you can reach a settlement, a lump sum settlement that typically will require that you resign from the employer. That's an insurance company requirement usually, and will settle out your claim and pays you a negotiated amount, that basically would allow you to go and then basically deal with your injuries on your own.
I always steal the line from a very good mediator that we use. She always says, what you're doing is you're getting a divorce from workers' comp. They pay you a lump sum amount of money so they don't ever have to see you again. And that lump sum amount of money is just what would they have to pay in future medical care, in essence, unless it's permanently and totally disabled. What would they have to pay in future medical care? And what amount would they have to pay you for you to accept to go away? If they thought they were going to have to pay $20,000 in future medical care over your lifetime, they wouldn't offer you $20,000.
Right.
They would say, okay, I can put away $15,000 now and pay 20 over that injured person's life. And so the reductions are always smaller than what the value is. But there's something we always got to be careful about when we talk about lump sum settlements. And you and I have had this a few times very recently, and that's the MSA, or the Medicare set-aside allocation.
Yes.
I know we only have about 11 minutes, and a whole Medicare set-aside allocation discussion would take at least 11 hours.
We will have no listeners left.
But really what Medicare set-aside allocation is Medicare doesn't want people to turn to Medicare for a payment of work-related expenses when they settle their case. Because workers' comp's supposed to pay that. And if workers' comp's supposed to pay it, then why should Medicare pay it? And what had happened previously, Medicare would say, okay, work comp, you have to pay it. And workers' comp would say, no, we settled the case. We gave the money to the client. And so there was this vacuum, so to speak, that there was no money to pay for, or no way to pay for the medical care that this person needed. So Medicare, and I guess it is just Medicare, came up with the Medicare set-aside allocation amount. And without going into great details of how to come up with that, it's really just a huge deductible that Medicare would not have to pay for anything work comp related until that deductible has been met.
And that's it used to be just in the bigger cases that settled 250 or more,
Right.
but now we're seeing that push down a little bit lower. And for anybody that's on Social Security disability or is close to retirement age, any of that, it's very important. So it's a very complicated process that does require a lot of explanation.
Right. And that's why it's important that you talk to a
If
workers'
you've got
comp attorney.
those kind of
Before you settle
issues,
anything,
right.
you got to talk to a work comp attorney. Because MSA or the Medicare Set Aside Allocation may come into play. The insurance company may be under evaluating your future medical needs.
Right.
You may be entitled to certain wages that you did not receive. So it never hurts to talk to an attorney before you sign any paperwork that some insurance company is trying to bring you to.
Oh, my goodness, yes. No, that absolutely.
Which leads me to insurance companies trying to have you sign paperwork, and that's in the auto accident arena all the time. Too many times we've had clients say, an insurance company that has
She'll remain nameless, but
Flo came over to me and said, here, let me write you a check, and all you have to do is sign this piece of paper. And in essence, they settled their case 2 days after the accident without really knowing that they were settling the case.
Yes, very common. There's really no one should be settling any personal injury aspect of their claim without knowing what their real situation will be and really having some legal guidance. Now, the situation is, if you feel fantastic, you think, I got no problem. But, you really don't know that.
You don't know that 2 days or a week into the accident.
No, you really don't. It takes a while for the body, really sometimes different things to be revealed. So that's something to be very careful about. The insurance company is not trying to help you. They're just trying to close that claim. And a lot of people will think, that they're just settling up their property damage, or that they're just, the insurance company is just giving them some money towards some particular thing. They're not understanding that if you do end up with an actual issue related to that auto accident, you've just given it all away for a couple $1,000.
Right.
Kind of thing.
I've heard stories of, because now massage therapy is not covered under PIP.
Mm-hmm.
And so the at-fault driver's insurance company will say, well, what do you think? You need $1,000 worth of massage therapy? Okay, let me write you a check for $1,000. And then they sign the general release, releasing them of all claims. Right. So it is very important, if you're involved in an automobile accident, that you talk to an attorney. We do no-cost consultations, and almost every personal injury law firm does a no-cost consultation. Right. So it's better to talk to somebody before you just sign a piece of paper from an insurance company.
Right. Because, you think about it. If they're offering you any money, they think there could be a claim there.
That's right.
Basically, why would they be doing that? So they're just trying to foreclose any real liability of any significant amount. So, doesn't do any harm whatsoever to just pick up the phone, make an appointment with a personal injury attorney. We handle cases all the time that maybe are just a consultation, just to let people know what their rights are and have a better understanding of the system.
Right. And you and I were driving down here to the radio station from our office, and we both commented when we got here of the traffic that's going on.
Oh, my goodness, yes.
So Pinellas County and Tampa Bay, there's a lot of cars driving, especially Thanksgiving holiday.
And we're in the season now, too, pretty much, are getting there.
So if someone is involved in a crash, God forbid, during this Thanksgiving holiday, what are the 3 things that they should initially do if they're involved in the crash? What
3 things? Is this like a test? What?
Kinda, yeah. Well, just top 3 things, and I'll give you my top 3 things. You want me to start?
Yes, because I have no idea where you're going with this.
Okay. If you're involved in a crash, the first thing you got to do is exchange information. Try to get the information from the at-fault driver. Pull over. You got to pull over.
If there's any significant damage at all, you need to be calling the police.
Right. The police don't always come, though.
That is true.
But one thing people think is that they need to keep their cars where they were. That's just the opposite. The law says that they have to move their cars if it's blocking traffic. Mm-hmm. So one thing, move the car and get information if you can. If it's a road rage kind of thing, stay in your car.
Yes, that would be one
Don't
time
do
I would not
anything.
get the information.
That's right.
Maybe
Wait
get
for the
the
police
license
to
plate or
come.
something.
Yeah. And then secondly, I would say take photographs. You need to take more photographs of the property damage of the area where the crash occurred. I met with somebody very nice. She gave me some photos, but they're all close-up photos that I can't tell, A, what part of the car it was or how the accident happened just because of the way the photos. In today's age of cameras on the phones, take so many photos that they can't.
But, you're not always thinking about that. I mean, when I got rear-ended last year, I did take photos.
Yeah.
But when I looked at them later on, they weren't terrible, but they weren't as good as I would have liked them to be.
That's right. And the third thing I would do before is to make sure you get medical treatment. You need you need to get medical treatment. In the state of Florida, you pay for personal injury protection benefits. And so it's $10,000 worth of lost wages and medical that you're entitled to if you treat within 14 days. If you wait 15 days from the date of accident, you don't get those benefits that you paid for.
You do not do what I did, which fortunately I wasn't ultimately hurt, but I did have some pain in my hand, and I kept thinking, when I go, and blah, blah, blah. And you really need to go within that 14-day period. Go see the doctor, go to the clinic, whatever. Just, if you've been at the emergency room, you're covered. But but you really do want to get checked out.
Right. Yeah. What about talking to the insurance companies? Should you talk to yours? Should you talk to theirs?
You're certainly going to call yours and let them get the claim set up. But you do not want to be talking to the opposing or the driver's insurance who caused the accident. No, you definitely want to have an attorney assist you at that point.
Right.
You don't need to be doing that.
Right. And what about talking to a lawyer?
Well, I mean, that obviously would, if it's a situation where there's going to be communication with that other insurance company, you need to have a lawyer. And in this scenario, that obviously we would recommend that. I think, even if you aren't, we want to hope that you're not going to have lasting injury, but if you are having any kind of issue at all, really, you should seek out consultation with an attorney.
And it doesn't hurt. I always say the best thing to happen is you talk with us, we sign you up, and 6 months from now, you're all better.
Fantastic.
You don't know what's a penny.
Right.
So it's good to have somebody watching out for you during the time that you need to, that things are going on that we're experts in.
Right.
And that you may not be. And so
probably are, because some people will have had the misfortune of being in more than one accident of significance, but a lot of times it's the first time the person's been in an accident.
Right. No, I agree. So those are the things that I think are very important.
Well, I'll give you an A. I think those are very good.
Thank you very much. We are about to wrap up. We do have about a minute left. It is Thanksgiving in a few days.
Yes.
And so I just wanted to take just a minute to say what I'm thankful for. And I'm thankful for you, of course, Lori, as my friend and as my partner, and I'm thankful for our staff who really do care about our clients. But I'm very thankful for our clients. I always say we meet a lot of great people.
Oh my goodness!
After bad things happen to them, so it's an honor to fight for them
and have the opportunity to be of help to those people. No, I'm so grateful.
Yeah, and I'm of course for family and such.
Absolutely.
Like that. So it's wonderful. But this does wrap up this week's show. This is FLA Law on the Radio. Next week, we will have Bill Damas here to talk about long-term disability. In the meantime, have a wonderful Thanksgiving season. God bless you, and may you drive safely and watch out for those who don't. Have a good night.
Good night.